was sent out.
All right, I have it right here in front of me.
Mr. Chahowski,
Yes.
your original letter that was sent out on March 23rd said that it was to be via Zoom. Another letter was sent out on May 13th because instead of a review, it was going to be a violation. And that violation was changed to be a hearing in court. And Mr. Marana tried to reach out to you regarding this and was unsuccessful. So did you not have the right contact information?
So I did not have any good contact for him. I have emailed him and he has failed to appear for appointments on May 23rd and June the 7th as well. So I've had no contact with Mr. Chahowski for.
When's the last time you had contact with him?
Last time we had contact was May the 9th.
So, Mr. Chahowski, how did you think probation was supposed to go? Did you think that you just checked in when you felt like it?
No, not at all. I understand my civic responsibility. That's why I'm with you.
Right out of the gate, the defendant explains his absence by pointing to an old letter and pretending confusion about dates. The judge immediately clarifies that the hearing was changed, notices were sent, and attempts at contact were made. This isn't a technical glitch. It's neglect dressed up as misunderstanding. The court isn't confused, it's unimpressed. From the very first exchange, you can tell the judge is already tracking patterns. Missed communication, selective attention, and excuses that only surface after consequences appear.
I'm in the process of moving, and I've changed locations. And since I moved locations, my email has been locked.
The judge walks him through the paper trail step by step, explaining how Zoom became an in-person hearing and how probation tried to reach him. Instead of accepting that explanation, the defendant shifts blame to scheduling issues and lack of contact. The problem is simple. Probation is not optional. The court expects proactive communication, not reactive explanations. At this moment, the judge is still calm, still patient, and still giving space for reason, even though the responsibility failure is already obvious.
Probation officer through my email. And I'm dealing with that right now.
Well, is your phone number the same?
No, I got a different.
Asked how he thought probation worked, the defendant insists he understands civic responsibility while demonstrating the exact opposite. He claims participation simply by logging into Zoom, ignoring the fact that physical presence was ordered. Then comes the email excuse, which somehow involves moving locations and a mysteriously locked email account. The judge listens, but the credibility meter is dropping fast. These explanations don't show hardship. They show avoidance and a refusal to take ownership of basic probation duties.
You change address and phone number. Don't you think it would be a good idea to make sure your probation officer knows that?
Well, I think it's a good idea, but you got to understand I've been dealing with my father's death that I caused, and I've been dealing with cleaning out the house, and I've been trying to find an apartment. Yes, I understand that, and I do understand my civic responsibility. I do, this is the first contact that I've gotten at this location, and I'm happy to give my phone number and my address.
The defendant introduces personal tragedy and emotional hardship, clearly hoping it will justify the lack of compliance. The judge acknowledges the loss but draws a firm boundary. Grief doesn't suspend probation rules. The court's message is clear and fair. Life can be hard, but responsibility doesn't disappear. What stands out here is restraint. Many judges would cut this short, but this one continues explaining expectations instead of escalating, even while being challenged.
We'll adjourn this 1 week, so it will be set again a week from today. At the same
Why do you
time,
want to see me in person? I don't know if I can go down there. I'm not sure if I can do that. I don't have a driver's license. I cannot drive. I can't be going anyplace. You know, my license is restricted. So I'm not really sure whether or not, and I'm not sure the reason you want me down there. For what reason? To put me in handcuffs and put me in another.
When ordered to appear in person the following week, the defendant pushes back immediately, citing license restrictions and implying the court's motive is jail time. This is projection, not reality. The judge explains that if incarceration were the goal, it would already be happening. Instead of hearing that reassurance, the defendant doubles down on suspicion. The tone shifts noticeably here from defensive to confrontational, and the court begins documenting the refusal clearly for the record.
This will be real simple. I want to make sure you can hear me okay, and I'm a little concerned at your tone.
Well, I'm a little concerned about what you're stating. I'm a little concerned. You want me down there for what? For what reason?
Okay, so I will note today that Mr. Jowski was aware that he was supposed to be here today. Mr. Jowski has indicated that, oh, hang on a second. Mr. Jowski, can you hear me? Mr. Jowski, can you hear me?
Yes, I can, officer, or honor.
All right, this is real simple. I'm indicating to you right now that it is the order of this court that you present yourself to the court a week from today. Are you telling me
Your Honor, I'm not going to court. I cannot get there, all right? Period. That's my life.
The judge asks a simple question. Do you understand the order to appear? The response is a flat refusal. No confusion, no misunderstanding, just defiance. The judge warns plainly that ignoring the order will dramatically change his circumstances. Even then, the defendant insists he will not appear. This is no longer about logistics or hardship. It's about rejecting authority outright, and the judge treats it exactly as such.
And he can adhere to that. I cannot go to court. Last time I went to court, they put me in handcuffs and put me in jail for 44 days. I'm not going.
Was that Mr. Jowski?
As the defendant raises his voice and interrupts, the judge draws a line on tone and respect. The violation is clearly stated: failure to appear and failure to comply with probation conditions. What's important here is that the judge shuts down the argument without shutting down options. He explains consequences calmly and gives one final chance to course correct, despite open hostility and refusal to listen.
It was Macomb County, but I know why you want me to go down there to put me in handcuffs. What the hell did Your Honor, what did I do? What did I do?
Mr. Jowski, I'm happy to explain it to you. You have failed to appear for probation appointments.
No, I did not. No, I did not. I told you why I didn't.
Boy, that escalated quickly. I mean, that really got out of hand fast.
Listen to me.
All right, Mr. Jowski, I'm not gonna tolerate you speaking to the court in that tone. You failed to appear today. You've indicated, no, Mr. Jowski, I've hit you on mute. I have nothing more than I need to hear from you. I've indicated to you that you have 1 week from today to appear at the court. If you're not here a week from today, then you're absolutely right. You will find yourself in a jail cell a week from today. If you show up a week from today and perhaps explain to me what's going on with you in a manner that's respectful, he's not listening.
No.
The judge openly acknowledges the defendant's mental health struggles and fear, explaining that the court is trying to avoid jail, not rush toward it. This is rare transparency. He offers a pause, a week to reconnect with probation, and a chance to fix violations outside custody. The defendant, however, continues assuming bad intent. The contrast is stark, one side offering structured help, the other insisting it's a trap.
This violation for 1 week. I'm going to adjourn this violation and it's going to be in person. Now, during that week, I am inviting you to reach out to your probation officer because nothing is etched in stone. Your last experience where you went in person to court, you did 30 days, okay? Now, you are not in compliance with probation, but that doesn't mean that I automatically go to the consequence of a jail sentence. Because I know, Mr. Chahowski, that with you there are also, there are many different challenges, including some mental health challenges that you try to work through. And I know that your rage at the court right now and inappropriate behavior today is a byproduct of fear and a byproduct of I know there to be a significant mental health challenge. So I am willing to wait and pause and give you a week to respectfully reach out to probation, understand why you're in violation, try to see if you can correct those violations and come up with a plan outside of the jail setting. I am at least willing, even now, to consider those opportunities. I have not made a snap judgment about you, Mr. Chahowski. I have not come to the conclusion that you are unredeemable or that you need to do 93 days in jail. I simply ask that you not make a snap judgment about me or my probation department. Everybody here is required, wait, I will unmute you in a second. Everybody here is required to meet certain standards. You are here for criminal behavior that needs to be addressed. I know when your mouth is open, sir, that you're not listening to me. I know when your mouth is open, I will unmute you and you can make some comments in a second, all right? But I know when your mouth is open, you're not hearing me. You made an assumption. You've made an assumption that I'm trying to figure out a way to put you in jail, all right? I'm simply trying to get you to come here as anybody else who has a violation. Everybody else who has a violation is here today in person. Everybody else. I don't have a special set of rules for Daniel Chahowski. You have to meet the...
Despite repeated warnings, empathy, and clear explanations, the defendant states on the record that he will not appear. The judge responds by doing his job, formally noting the refusal and warning that a bench warrant will follow. No anger, no theatrics, just consequences. This wasn't a setup. It was an opportunity squandered. If you like this breakdown, hit the like button, subscribe to the channel, drop your thoughts in the comments, and we'll see you in the next video.